Good afternoon, ladies and gentlemen. Welcome to MECA Webinar sessions. Today, we are very privileged to have Mr. T. Balasubramaniam, the chairman of MECA, and together with Ms. Sujata, one of our finest IR consultants in MECA. Both Mr. Bala and Ms. Sujata will be presenting on Appellate Judgements on Employment Law. Well, if you are into social media, as you can see through our first page here, please like us on Facebook, follow us on Twitter, as well as add us on our WhatsApp group chat here. Alright, so moving forward, I would like to make a little bit of introduction on Mr. Bala today. Well, Mr. Bala, as I mentioned, he's the chairman of MECA. He has been involved in industrial relations for the last 30 years, having retired as Senior Industrial Relations Advisor from the Malaysian Employers Federation in 1996. His experience includes providing consultation service on industrial relations, representing employers at the industrial court, labor court, conciliation meetings, collective bargaining, and conducting numerous training courses in the field of industrial relations. Now, get this, he is also the author of the book, A Guide to the 1998 Amendments to the Employment Act 1955. Well, without further ado, I will pass this time to Mr. Bala as well as Ms. Sujata. Okay, Mr. Bala, all yours.
Thank you, Alvin. Good afternoon, ladies and gentlemen. We are going to speak to you on the topic Appellate Judgments on Employment Law. These are mainly industrial court awards over which either the employer or the workman, being dissatisfied, and applied to the High Court for to obtain an order of certiorari to quash the award. Now, sometimes when the High Court quashes the award, the other party will challenge it, take it up further to the Court of Appeal. It may get reversed there. The other party being dissatisfied with that can take it up to the next level, which is the federal court. That is the highest court, as you know, in the country. So these are three levels. Start with the industrial court. Next step is the High Court. Then the Court of Appeal, followed by the federal court. Now, what we are going to do today is to look at a total of 12 judgments. And I have with me my colleague Sujata. She will read out the facts of each case. When she has done that, I will do the commentary. Over now to you, Sujata.
Good afternoon, ladies and gentlemen. The first case is Mark Wankit versus Reed Exhibitions. Mark Wankit, the claimant, claimed constructive dismissal when he was reassigned from his position as country manager to International Sales Force Area Manager. He claimed that the reassignment was a demotion. The industrial court held that the reassignment was not a demotion and dismissed his claim of constructive dismissal. The claimant then applied to the High Court for an order of certiorari to quash the industrial court award. The High Court dismissed his application with cause. Now, I will hand over to Mr. Bala for his comments on this case.
Now, when the person has been reassigned from one job to another, sometimes, as you know, they accept it, but you may have some cases where they protest. No, I'm not trained for that, or I don't like that, or whatever it is. So in this particular case, the person was reassigned and he decided to treat it as a ground for constructive dismissal, and he lost it. So what it tells us is, it is okay to reassign, but